from St. Louis Public Radio. This is St. Louis on the Air.
It's literally in the Missouri Constitution now that people of this level of income qualify for Medicaid. And that's just the fact. It's literally in the Missouri Constitution.
I mean, frankly, I wanted to convict these guys after reading these texts.
Yeah, I was ready to convict them before I read the text, but I don't think they can keep these texts away.
Yeah, I mean, I always find it interesting if you're caught in a position of arguing that something is so inflammatory and so incendiary, but the problem is your clients are the ones that actually said those things. I think you're in a bad position. I mean, as the defense attorneys, right?
And the state of mind is an element of the crime. So it is not sufficient that somebody has been injured. You have to prove, the prosecutor has to prove that the defendant intended the result. And I believe that these text messages allow that to happen.
Welcome to St. Louis on the Air. I'm Sarah Fensky. Cole County Circuit Judge John Beadham is currently faced with a $1.9 billion question. Does the state of Missouri have a legal obligation to provide Medicaid services for an expanded pool of residents, as state voters indicated last summer? Or does the fact that the Missouri legislature provided no additional funding for those services mean that residents will not see that additional coverage? The question has big implications for both low-income Missourians and the state's finances. Our Legal Roundtable convenes today to discuss the legal questions that underpin the answer, and a whole lot more. We'll talk about prosecutorial misconduct. We'll talk about manslaughter charges against a mother. We'll talk maybe about the McCluskeys. And joining us now to do just that is Eric Banks. He's a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. Eric, welcome back.
Hello there.
And we're also joined today by Nicole Gorofsky. She's a former prosecutor, now in private practice at Gorofsky Law. Nicole, welcome.
Good afternoon. Thanks for having me.
And last but not least, we're joined today by Bill Freivogel. He's a journalism professor at Southern Illinois University Carbondale, as well as an attorney. Bill, welcome back.
Hi.
So, Bill, supporters of Medicaid expansion filed their lawsuit to force coverage last Thursday. That was on May 20th. It's now set for trial on June 18th. Isn't that quite a bit faster than the wheels of justice generally turn?
Yes, it is faster than usual. I take it there's a stipulation of facts in this case, which so as I understand it, mainly from actually reading the Missouri Independent about the case, that this will be just arguments on the legal issue. There won't be all sorts of witnesses called, and we're just going to be deciding the issue of law. And it is a $1.9 billion question, but what oftentimes doesn't show up till the end of stories is that if Missouri expanded this, if they went right ahead and willingly expanded the Medicaid, that it would get $1.2 billion more from the federal government for its Medicaid program.
I think that's a great point. When I say $1.9 billion, I'm talking about the whole cost. A huge chunk of that comes from the federal government. The state cost would be just $130 million. And there's a lot of arguments to be made that this will, in some ways, pay for itself. That is not going to be the issue that the court is deciding. No. Nicole, what is the issue here for them?
So what's interesting about this issue and what actually may attribute to some of the speed in which it's getting to trial is this is actually filed as an injunction and declaratory relief. So normally what would happen in a typical lawsuit is I think it's July 15th is the date that someone would normally go and apply for their Medicaid expansion, be denied, and then file a lawsuit. This is different. What they did in this case is the plaintiffs are people who would be eligible on July 15th, But what they did is preemptively, they filed for an injunction against the state to basically say, we believe that we would win. And so if we were to go to trial, and so what we're doing is we're looking to enjoin the state from preventing us from signing up. So a temporary injunction, what's interesting about that is that it does have sort of an urgency element to it, because you have to prove that there would be imminent harm or irreparable harm if it was denied. And so that gets them a more speedy hearing. And so therefore the issues are actually a little different than they would be in a lawsuit, which typical lawsuit, so they have to show that they would be likely to succeed on the merits. They have to show that they would suffer irreparable harm. They have to show that there is a balancing of harms, meaning making the state do this wouldn't be more harmful than it would be to the plaintiffs, and that there's a public interest that favors the injunction.
Seems like this makes a lot of sense to bring this lawsuit this way. Eric Banks, by the governor saying flat out he is not sending forward a Medicaid plan, he does not plan to expand this pool, did he open the door to these lawyers being able to argue this case this way?
Yes, he did, as well as violating the desires and the dictates of the voters. And no one has ever accused Missourians in general for being overly liberal, and for the voters to go to the voting box and approve this. Certainly the will of the people has been expressed. And now it's the legislature's responsibility to find the $130 million as their contribution to get this done. Society is judged by how we treat the least of us. And certainly the least of us would include people who would qualify for Medicaid. And it's a sin and a shame that this type of litigation has to take place.
So, Bill, I mentioned this is before John Beadham, who is a judge there in Cole County. Seems like he gets a lot of high-profile cases. I guess that's part of being in Cole County. Do we know anything about, how he might land on a case like this?
I mean, I don't know where he will land. I noticed he, in a recent decision, he ruled in favor of state employee labor unions and against the Republican passed bill in the legislature that would have treated state workers as at-will employees and sort of edged out the labor unions. But I have no way to predict, how he will where he will go with this one.
So something that was predicted to me is that no matter what Judge Beadham does, that this ultimately does not rest in his hands, that this will go to the Missouri Supreme Court. Eric, do you think that's a fair bet?
Yes, and of course it would go to the Missouri Court of Appeals, Western District in Kansas City before it went to the Supreme Court. But I think that the smart money says that eventually our new Supreme Court will be deciding what ultimately will take place.
You mentioned our new Supreme Court. There's actually some pretty big news in the state of Missouri. This involves a new justice who was appointed by Governor Parson, Robin Ransom. She is the first Black woman to be on the Missouri Supreme Court. Nicole, this feels like a pretty big deal.
It is a very big deal. It also feels, too late. But here it is, here we are, and it's a good thing, whether it's too late or not. And it's very exciting for Missouri.
So we saw praise on this appointment from people who don't normally praise Governor Parson's choices. Does that tell us anything about Robin Ransom's record as an appellate judge or as a lower court judge? Bill, do we have any sense of whether this might be favorable to this case to have her on the Supreme Court?
Well, I haven't studied her record, but she certainly has her biography is inspiring. I think she mentioned the other day that her father was a firefighter who was in a segregated firehouse. Also, that her family still has family in the Fairground Park neighborhood of North St. Louis. I also noticed in her biography that she's been, not only was she head of the juvenile court, I believe, at one point, but she also has been very involved in issues involving involving young people. And as you say, I believe the Legislative Black Caucus expressed their approval at this appointment. I think it says something for the nonpartisan court plan, which so often, sometimes is the subject of a lot of criticism. But it shows that when you have a panel of three well-qualified people presented, that sometimes maybe you don't have the same kind of ideological edge that we sometimes get in presidential appointments to the U.S. Supreme Court, for example.
Nicole, you have some thoughts on this?
Yeah, I mean, you almost can't get a better resume, which is, goes along with what Bill was saying, is she was a public defender, then she was a prosecutor, and then she was a family court commissioner, then she was on the circuit court, then to the Court of Appeals, and now on the Missouri Supreme Court. I mean, it doesn't get better than that.
Eric?
I certainly agree with Nicole in the fact that the judge also graduated from one of the best law schools in the United States. My alma mater, University of Missouri, Columbia, has nothing to do with my high praise.
So we think the Missouri Supreme Court, with Robin Ransom on it, could end up getting this case. Nicole, what do you make of the merits of this argument? Do you think this is going to be a slam dunk for the people trying to force Medicaid expansion?
I think it should be. It's in the Missouri, it's literally in the Missouri Constitution now that people of this level of income qualify for Medicaid. And that's just the fact. It's literally in the Missouri Constitution. And so if the Missouri Supreme Court is there to interpret the Missouri Constitution in this way, then that's how they should find.
So I want to talk about one other matter involving state government. This has to do with a new law passed by the Missouri legislature seeking to protect businesses from liability on COVID-19. And the idea is, the governor says, they don't want to see frivolous lawsuits. We were all in the middle of a pandemic. It was very hard to know what to do and how to keep people safe. Some plaintiffs' attorneys have been very concerned about this. Eric, do you think they should be?
Yes, I do, but I would be more concerned about the challenges of satisfying the burden of proof, regardless of whether or not this law exists or not. It's still going to be a heavy burden to show that your client got COVID at this location as opposed to someplace else.
One of the things that was pointed out to me on this lawsuit is the fact that even beyond that, which that's a difficult part, apparently there's no emergency clause in this legislation. And so this is something that isn't going to go into effect until August. It seems like the pandemic is kind of winding down in Missouri. I certainly don't want to get ahead of myself, knock on wood. The fact that there is no emergency clause here, Nicole, do you think this will even end up being that big a factor to get this thing on the books?
Yeah, I mean, so that's an interesting thought. Are people going to rush to file their lawsuits between now and August because there's no emergency clause, meaning that it won't be? So anything that's filed before August, of course, will not have these legal standards that are in this legislation. And these legal standards make it harder to file this type of lawsuit. I mean, that could be an issue. I think that's maybe was an interesting compromise. It's hard to say for sure. I do think it's, I think this legislation could end up being a problem, and we're just going to have to see how it plays out and how courts end up interpreting it. But it could be used more broadly than anyone wanted it to be used. And so we're just going to have to see how it plays out.
Eric?
And least anybody think that this is going to be a panacea for employers. I would like to remind the listening audience that employers are protected by what's known as the comp bar, and the exclusive remedy for employees who have claims of being injured on the workplace with their employer as opposed to a third party is workers' compensation. And Missouri's workers' compensation reimbursement rates for employees is not very high, especially in comparison with some of the surrounding states, such as Illinois.
So for a worker who's alleging they got this on the job, you're saying they're going to have a really hard time getting a substantial payday even before this?
Well, I think the idea of a substantial payday under any circumstances is non-existent. But even if this law were not to come to pass, it would not be a slam dunk, that there would be any large recovery by an employee against an employer when the employee is claiming, I got my COVID from my workplace.
We're talking.
When the bill goes into effect, the standard is incredibly high that the owner knowingly and purposely caused somebody to get COVID. I mean, how in the world do you prove that?
Nicole.
Yeah, and then the other issue is, so half of the issue is employers. The second half of the issue is medical malpractice. And so when Eric is saying that, the workers' comp bar is very influential, the medical bar is also very influential. And so basically this makes it very difficult for people to bring medical malpractice claims related to COVID. And that's the part where I'm saying it could be interpreted more broadly than that. And it just remains to be seen. This really could be detrimental to people who have true medical malpractice claims.
We're talking today to our legal roundtable. That includes attorneys Nicole Gorofsky, Eric Banks, and Bill Freivogel. And if you have a question for the panel about something we're discussing, you can give us a call at 314-382-8255. That's 382-TALK. You can also send us a tweet at STL on air, or you can email us at talk@stlpr.org. We need to take a quick break. When we come back, we're going to talk about a high-profile federal case against some St. Louis cops who are accused of beating an undercover colleague. What about the text messages they sent each other? Is that something that the jury has the right to see? Is that something the public has the right to see? And we will also today talk about the misconduct allegations against Circuit Attorney Kim Gardner. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.
And now back to our conversation. We're talking today with our legal roundtable. That includes Nicole Gorofsky. She's a former prosecutor, now in private practice at Gorofsky Law. We're also joined by Eric Banks, a former state prosecutor and city councilor for the city of St. Louis. He's now in private practice at Banks Law. And last but not least, Bill Freivogel, a journalism professor at Southern Illinois University Carbondale, as well as an attorney. And we're going to turn now to a high-profile case involving some bad cops. A month ago, a St. Louis jury deadlocked on charges against former police officers Dustin Boone and Christopher Myers. They were accused of beating an undercover colleague, Luther Hall. Now federal prosecutors are planning to retry both of them. And earlier this month, prosecutors filed a motion with new evidence they plan to use in the case. That includes some incendiary text messages. The defense attorneys for these former officers were not happy about this. And one of the arguments they made in trying to say that prosecutors should face sanctions and that these should not be allowed to use, they pointed out that some of these text messages were between former officer Dustin Boone and his then girlfriend. Well, Dustin Boone and his girlfriend got married. They got married about a year after this beating incident. And prosecutors are saying they can use this. Defense attorneys are saying they can't. Nicole, why is this even an issue here? How does the law work?
Well, there actually is a marital privilege in Missouri, which has always seemed a little strange to me, but it does exist. And so married people can't be compelled to testify against each other. Now, the text messages exist and they're out there in the world. And I don't think the marital privilege covers the fact that the text messages exist. And so I don't think that's the issue. I think the issue is that if them getting married at this point can prevent the girlfriend then becoming the wife from testifying. I think that if you can present evidence that the marriage is fraud solely for that purpose, I think is what the prosecutor is saying, that negates the marital privilege. I think I'm not sure how the court will come down on that issue. That's an interesting argument.
Yeah, I mean, they're making the argument of the forfeiture by wrongdoing rule is what the prosecutors are saying here. They're basically saying that he only married her to prevent her from testifying. It seems like they'd have to bring in a bunch of evidence before you could say that about a marriage. Eric, is that a tough hill to climb?
Well, they call this the practice of law for a reason. I've never heard of the marital privilege being extended to a time frame even before you were married. So what's up with that? Are we going to have next a fiance privilege? And in addition to that, if I can get on my high horse for a minute,
I would welcome that.
I think that anybody who believes that there is a reasonable expectation of either privacy or confidentiality with any type of text message needs to have his or her head examined. I would like to think that I am many things, but stupid is not one of them. Well, not excessively stupid anyway. And I would never put in a text anything that I wouldn't want to read about or hear about on St. Louis on the Air.
You know, and some of these texts were just horrible. I mean, we're kind of laughing about the stupidity of putting these things in writing, but there were some appalling racist sentiments in these texts and just frank talk about beating people up, trying to avoid cameras while beating people up. After federal prosecutors included these texts in a brief that was available to reporters, the Post-Dispatch ran a story. The Riverfront Times actually put them on the cover of the newspaper. And defense attorneys are saying these are inflammatory, they're irrelevant, and highly prejudicial. They do seem quite inflammatory. Bill Freivogel, do these guys have a right to keep these under wraps, at least as far as the jury is concerned? I mean, frankly, I wanted to convict these guys after reading these texts.
Yeah, I was ready to convict them before I read the text, but I don't think they can keep these texts away. And you know what I read from a piece that Lauren Traeger has on KMOV, the judge doesn't think they can either. Mm-hmm. So it doesn't seem to be too impressed by the defense arguments. I mean, in one of these texts, I believe it's Boone refers to the circuit attorney as a plate lip. You know, as long as the plate lips are in charge of the circuit attorney's office. I mean, and this is just horrible, gross.
Yeah, I actually feel bad that we just even said that on the air. I mean, it is so horrible, and
it is so horrible. Yeah. It is. Maybe I shouldn't have said it. Well, but that's what we're talking about here. And you know, these messages are also. I mean, they're not just to rile up a jury, although I suppose they could do that. But one of the things that in a federal civil rights case that has to be proven is willfulness to violate somebody's civil rights. And certainly these go a long way towards doing that.
So Bill mentioned this story from KMOV. They reported yesterday that a judge has ruled that the text messages containing racial slurs can be used in that trial. KMOV also reported the judge also ruled prosecutors will get to call Dustin Boome's now wife to testify on the stand. After ruling there was evidence he married her just to prevent her from testifying. The judge, however, said the evidence about Boone and drugs, because there was also a lot of talk about apparently using drugs right before going on shift, he said that evidence will not be allowed at trial. Nicole, thoughts on all this?
Yeah, I mean, I always find it interesting if you're caught in a position of arguing that something is so inflammatory and so incendiary, but the problem is your clients are the ones that actually said those things. I think you're in a bad position. I mean, as the defense attorneys, right? I mean, you're trying to prevent public acknowledgement of something that your clients actually did. And it looked like the defense attorneys were actually seeking sanctions of the prosecutors for putting this in pleadings. And I mean, these are pleadings, and the prosecutors have to do what they have to do to get the information into court. And, so, if you can't handle what you said, don't say it.
Hmm. And it does seem, Eric, that this speaks to this issue of intent.
Yes, I agree. Admittedly, I got D's when I studied Latin at Lutheran North. I guess I was cheating off the wrong person, but there is a Latin phrase, which I don't remember and certainly cannot pronounce, that talks about the state of mind. And the state of mind is an element of the crime. So it is not sufficient that somebody has been injured. the prosecutor has to prove that the defendant intended the result. And I believe that these text messages allow that to happen.
And in federal civil rights cases, that require the amount that has to be proven in terms of willfulness is even greater than just in normal criminal cases. One thing that came out yesterday, according to this KMOV report, there was an injury report written involving Luther Hall's injuries, and the report reminds me of the one that's gotten a lot of attention involving George Floyd. This injury report by the St. Louis police said, as officers were making arrests, Officer Hall was knocked to the ground, striking the concrete.
The passive voice there is, wow. Well, we're going to talk about a different instance of prosecutor misconduct or allegations of prosecutor misconduct in just a little bit. But before we do that, I want to talk about a different criminal case. This is an absolutely heartbreaking case out of Alton. A woman named Amber Hampshire has been sentenced to 7 years in prison after pleading guilty to 1 count of involuntary manslaughter. She's charged with causing the death of her daughter, Emily. This was in November of 2018. Emily had diabetes, and her mother failed to deal with it for 5 years. She even went so far as telling Emily's school that this girl did not have diabetes. And Emily then, at age 14, died of ketoacidosis. Nicole, does involuntary manslaughter make sense in a case like this?
Yeah, I think involuntary manslaughter makes sense. The charge makes sense. I think the sort of more interesting question here is whether the sentence makes sense. It was a 7-year sentence on this case, and tragic is absolutely the right word to define this case. So as I thought about it, and for some reason it's stuck in my head since I read about it, I go back and forth. And so, what happened was the mother learned the child had diabetes, knew the child had diabetes. And in fact, the child had gotten sick and had been in the hospital because of failure to care for that diabetes, and had been educated on, what happens if you don't treat the child. And 9 months after that hospitalization, the child died for lack of treatment. And the twist is mom also had diabetes, and mom also wasn't treating her own diabetes. And, so I first read this and I'm livid, obviously. I'm thinking, this is close to intentional murder, right? I mean, because now she knows about it and she's not doing anything about it. And then, then my head goes the other way and I think, but she wasn't treating her own diabetes, and it's absolutely tragic. And there was a psychiatrist who testified that mom had some mental illness and really couldn't deal with this on her own. And so, you go back and forth and back and forth. And actually the punishment range was up to 14 years. So the judge gave the 7. She'll serve probably 3.5. But I mean, if you can, it's hard to think of a more tragic case all around for everybody.
Yeah, I mean, this thing is just heartbreaking. 7 years does seem like more than I'm used to seeing in many involuntary manslaughter cases. Bill, any thoughts on that?
Well, it seems like an awful lot to me. I mean, the sentence that she's going to live with is living the rest of her life knowing she let her daughter die. I'm not saying that she shouldn't have been convicted, but a 7-year sentence seems awfully steep to me.
Eric, any thoughts on this one?
Sounds like a fair sentence to me.
We're talking today to our Legal Roundtable that consists of Eric Banks and Bill Freivogel and Nicole Gorofsky. We do need to take a quick break. When we come back, we're going to talk about the misconduct allegations against Circuit Attorney Kim Gardner. They have been talked about for a long time. Things are finally coming to a head. We'll have analysis of what that could mean. This is St. Louis on the Air on St. Louis Public Radio.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
Welcome back. Today, our Legal Roundtable is in session, and that includes Bill Freivogel. He's a journalism professor at Southern Illinois University, Carbondale. We're also joined by Eric Banks. He's a former state prosecutor. He's now in private practice at Banks Law. And Nicole Gorofsky, a former prosecutor, also now in private practice. Her firm is Gorofsky Law. I want to talk about a very high-profile case here in the St. Louis area, and that is the fact that Missouri's Chief Disciplinary Counsel has filed charges against Circuit Attorney Kim Gardner. He says probable cause exists that she's guilty of professional misconduct over her handling of the investigation into then-Governor Eric Greitens. Now, this all has to do with the former FBI agent she contracted with, William Tisby. Tisby and Gardner allegedly withheld Gardner's handwritten notes from an interview they had with a victim in the Greitens case. Tisby actually faces criminal charges for lying about their existence. And these charges against Gardner revisit some of the allegations against him. He lied under oath and said he didn't ask the victim questions. Well, it turns out he asked her 150 questions. He lied and said he didn't talk to Prosecutor Gardner during a lunch break. Well, in the 2-hour lunch break, phone records show they had 7 phone calls. She's accused of standing by while he lied about those things and more. And the Chief Disciplinary Counsel says that records show she made no attempt to correct his testimony. She even asked follow-up questions that elicited more false testimony. Nicole, thoughts on this?
Yeah, it's actually the disciplinary pleading, I guess I'm not sure exactly what they call those, an information or a pleading for disciplinary action against Kim Gardner is actually even a little worse than that. So she had her own notes apparently, and the court repeatedly asked if there were notes, and her assistants were up there and went and asked her repeatedly if she had her notes and if there were any more notes in existence. And it sounds like she said no, knowing when that they did exist. And so, yeah, I think this disciplinary action sounds pretty bad for her. You never want to be in that situation as an attorney. And Alan Protzel is, known for, it's interesting. Alan Protzel is the disciplinary counsel on the one side. Mike Downey is representing Kim Gardner. These are people that I respect. I think they're both good people. And I think they're both going to do diligent work. So, but it doesn't bode well for Kim Gardner.
There's something so interesting in this filing. Scott Rosenblum, of course, represented former Governor Eric Greitens, and he said, quote, "In effect, Ms. Gardner has made herself a case agent. She did not insulate herself in the way that is normally done by prosecuting attorneys. There's a reason why almost every prosecuting attorney would not have put themselves in the position that Ms. Gardner put herself in." And this was testimony that Rosenblum gave at one of these court hearings where they were discussing the fight over this discovery. Eric, what do you think was going on here? Why would she have put herself in this position where she's now facing what she's facing?
Perhaps because she did not have the same type of handlers that I had when I was a city councilor, who told me that you're doing too much. Why do you think that you have 40 attorneys working for you? Stop trying to do so much. That way, when something goes wrong, and it will, you'll have plausible deniability. But if you're an activist, if you're a crusader, if you're committed to trying to bring about meaningful legal reform in the city of St. Louis, and that takes the form of you actively monitoring your subordinates, you run the risk of something like this happening.
Nicole, this idea of being a case agent here on this, do you think if somebody else had been the case agent, that there would have been more pushback, that maybe they would have said, are you sure you don't have these notes? Or do you think based on the record you're seeing here from this disciplinary counsel, these notes were not going to get turned over no matter what?
Yeah, I mean, I don't like the concept of this private investigator having been hired, because I do think that when you work with more experienced people who are more familiar with the law where you are and have just been doing it for a longer time, they're going to tell you, no, these things have to be turned over. And I think she was a relatively new prosecutor at that time. And I think just that whole concept was probably fraught with danger. At the same time, she was asked direct questions, and I think failed to turn things over. And I think that's a problem.
Bill, what do you think about all this?
Well, I'm going to give a little bit more of maybe the other side of it. I mean, I think this is really, I mean, this is really an extraordinary case. I think when Gardner's brief by Michael Downey says it's unparalleled, it's really true. I don't know of any criminal case where defense lawyers were allowed to probe into prosecutors' files during discovery in the way they were allowed to in this case. I don't know of any Missouri case where a prosecutor's been subject to a criminal investigation, an ethics investigation, a search warrant to turn over all of the computer records in her office.
Do you think Judge Burleson gave the defense attorneys for this case too long a leash, Bill? Is that
Yes,
what you're saying here?
I do. Yes, I do. I mean, Brady violations are important. Brady is a Supreme Court case that prosecutors have to turn over material evidence that would help the defense. I mean, Gardner certainly has invoked Brady a lot. The 59 police officers who can't testify on her do not call list, or because some of them violated Brady. But I mean, this takes things to a whole different level. There was the Gardner brief cites the Center for Public Integrity study. They studied 2,000 cases over the whole country over 3 decades where convictions were overturned for prosecutorial misconduct. Only one prosecutor was disbarred nationwide over 3 decades. And remember, we're talking there about convictions. I mean, Gardner dismissed this case. So yeah, I think there. I mean, how I think this really should come out is that the next step along this process is a hearing panel, 2 lawyers, 1 non-lawyer. They could admonish the circuit attorney, and the 2 sides could agree on the admonishment, and never gets to the Supreme Court, and we can close this chapter.
Bill, my sense, I think that, I can see the merit in what you're saying. My sense is that they could have gotten away with these kind of discovery issues and potentially this alleged perjury if this was just your average defendant, if this was not Eric Greitens. On the other hand, do we want prosecutors hiding this kind of exculpatory evidence from a regular defendant? Nicole, do you have any thoughts on that?
Yeah, I mean, that's actually what was going through my head a little bit as Bill was talking is, yes, they were given more access. And I do think that is a huge part of the issue here, is that the defense counsel was given more free rein in this case than any other case I've ever seen. But they found something. And once they find something, now what do you do? And so, yeah, I think it is true that the fact that they were able to dig this way isn't fair, but it's also true that I think she made a violation. And so, that's what we're stuck with.
Eric, do you agree with Bill here that this is cause for a reprimand, not suspension or revocation?
Yes, I believe that. And keep in mind, a reprimand or an admonishment is not a slap on the wrist. It is something that attorneys fear. It could be the first bite at the apple, because the last thing, the second to the last thing that an attorney wants to have happen is to be investigated by a disciplinary counsel. That's the second to the last thing. The last thing that an attorney wants to have happen is to be considered by the disciplinary counsel or the disciplinary commission as being a frequent flyer. Because when you're accused of an impropriety, an indiscretion, or whatever euphemism you want to use, the first time, you may be given the benefit of the doubt. But if it happens a second time, it's going to be thought that lightning does not strike twice at the same spot. Mm-hmm. So no one wants to get the first admonishment because you don't have 9 lives as an attorney. You have about 2. And if you use one up with an admonishment, the next step will probably be a suspension, if not a revocation.
So a reprimand is a very serious consequence here. Bill, I don't know if you know the answer to this. If her license should be suspended or revoked, could she even continue to serve as the circuit attorney?
She could not. If that happens, she could not continue to serve as circuit attorney. I looked up, the requirements. Circuit attorney has to have the same requirements as a prosecuting attorney, and they have to be a member in good standing of the bar.
Well, say it's a 14-day suspension. I don't know if they even do suspensions that short, but say it's a brief suspension. Would she be able to come back after that? Or is it a matter of once you're suspended, you're no longer holding this office, we're bringing in somebody new when the voters have voted for her? Bill, any thoughts on that?
I mean, I don't know about that particular hypothetical. I would imagine she could just she could possibly just recuse herself for 2 weeks. I don't think she should have to. I think it would be outrageous for her to have to surrender the office that she's just been reelected to, with a large majority. I mean, this information was all out there before the election for the Supreme Court to take any kind of action that would remove her from office, particularly in light of the way in which she has been the target of the target of the kind of racial and white establishment attacks that we were talking about earlier. I think would be an outrage.
Eric, is that something you would agree with?
I certainly would, but once Bill and I agree with each other.
I'm glad we found this moment. And look, we're talking a lot about Kim Gardner and these allegations of misconduct on her part. But I want to talk about something here that feels like a little bit of a victory for her. The Missouri legislature signed off on a bill that would allow a prosecuting attorney to file a motion to vacate a past conviction if they have evidence, quote, the convicted person may be innocent or may have been erroneously convicted. Kim Gardner wanted to do exactly this in the case of a man named Lamar Johnson. He's a St. Louis man serving life in prison. She says she has evidence now that says he's actually innocent. The Missouri Supreme Court said she had no power to do anything about that unless the legislature passed a law like this. Well, the legislature has now passed a law like this. We're waiting to see if Governor Parson will sign it. But Eric, is the passage of this bill a huge victory for Lamar Johnson and a huge victory for Kim Gardner?
Well, I wouldn't use the qualifier huge. It is a positive step in the right direction. But as you said in your statement, the governor still has to sign it. So there's a lot of praying that needs to be done before we break out the champagne.
Nicole?
I mean, I think the last time we were here, I think, this is a little bit of a dig on Eric Schmidt. I think the last time that we were here, what we talked about was, prosecutors are supposed to be held to a different standard. They are supposed to do justice. They're not supposed to only advocate because, for the point of advocating. They are supposed to do justice. And if, a conviction is not valid, then they should, by all means, say that it's not valid. And so I think this is, dig because Schmidt's office was in there saying, no, our job is to fight no matter what, which is, I think, absolutely wrong for what the purpose of prosecutors are supposed to do. And so I think this is a correction of that.
So lawmakers have sided with Kim Gardner over Attorney General Eric Schmidt, at least in this one very, very limited instance. Bill, that's a little bit of a surprise right there.
Well, yeah, I mean, I do hope the governor signs that because, we have a case on the other side of the state that's very similar to Lamar Johnson, where a prosecutor, there's a progressive prosecutor over there too. And the prosecutors there say that a Missouri man, Kevin Strickland, has been in prison for 40 years for a triple murder he didn't commit. And so, once again, their prosecutor, because of what the Missouri Supreme Court did in the Lamar Johnson case involving Gardner's request, their prosecutor is without any power to go to court and say, hey, he should be released. So this bill if signed by the governor, would fix. I think, I hope, would fix that problem.
So we have just a final few minutes here. And in those final minutes, I'm going to talk about Mark and Patricia McCloskey. After the court booted Circuit Attorney Gardner off their prosecution, former U.S. Attorney Richard Callahan was appointed to take over. He's now filed a new indictment. It adds a misdemeanor harassment charge against Patricia McCloskey. And he also dismissed an evidence tampering charge against her. Now, she still faces one felony. That's unlawful use of a weapon. Now this misdemeanor exists as an alternative. Eric, is this Richard Callahan trying to give a gentle way out for Patricia McCloskey?
I wouldn't categorize it that way. I think that the decision is fair and equitable under the circumstances, and I would agree with what has been done.
Bill, I imagine you might go back to disagreeing with Eric on this, no?
I want détente with Eric.
Okay. You're not going to argue Patricia needs a felony here.
Well, I think my impression is that this now will give a potential jury a choice. If they think it's too much to convict her of a felony, then they have this misdemeanor to fall back on. I mean, Callahan has a very good reputation. And so I would tend not to second guess him and to agree with Eric.
Nicole?
I think one of the other things it does is it takes sort of the gun issue out of it. So people who are so concerned about, it's not fair, she had a gun on her own property, it takes that issue out of it a little bit. And this is just a straight harassment charge. So I think it maybe takes some of the public outcry out of it. I mean, it remains to be seen whether it really does. But I do think this was a interesting and good strategy on Callahan's part.
So what he did only applies to Patricia McCloskey. Her husband, Mark, had faced very similar charges. He's now running for Senate. Bill, I was kind of probing on whether the circuit attorney could serve as circuit attorney with a suspended license. Do we see any consequences for him if he ends up with a felony conviction? Can he be a U.S. senator if he ends up getting a felony conviction in St. Louis City, which is not beyond the realm of possibility?
I think he can. I don't think the qualifications in the Constitution say anything about a felony. And with some voters in Missouri, a felony on a gun charge that could be that's a badge of honor.
Yeah, I mean, the fact that it's him running for Roy Blunt's seat along with former Governor Eric Greitens, we were talking about his felony troubles earlier in the show. It almost seems like having been charged with a felony is a prerequisite to get into that race. Eric, what do you think?
Well, I wouldn't go so far as to say that it was a prerequisite, but I will take the hyperbole in the spirit in which it was offered. In other words, I don't think that that's going to hurt his chance of winning in the state of Missouri, unfortunately. And even with the very slim majority that the Democrats have in the Senate, they would not refuse to seat him over something like this.
We do have a note here from our producers. They have researched this just now on factcheck.org. They tell me the Constitution allows a convicted felon to be a member of Congress, even if they're currently in prison at the time. So I feel like this is something where Missouri, we could break some new ground here. But it sounds like Callahan may be offering a misdemeanor to Mark McCloskey down the road, too. We'll see how that goes. And of course, our Legal Roundtable will be all over talking about it when and if that happens. So Eric Banks of Banks Law, LLC, I want to thank you so much for joining us today.
Thank you for having me.
And Bill Freivogel of Southern Illinois University, Carbondale, thank you.
Thank you.
And Nicole Gorofsky of Gorofsky Law, thank you so much.
Thank you.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here. If you learned something new from today's episode, consider leaving us a review and rating on Apple Podcasts on the App Store. It's the easiest way to help people discover our show. We appreciate it. Thank you. St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.
Support comes from the Missouri Forest Products Association, providing more than 41,000 jobs in the production of wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details at choosewood.com.